Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're doing something a little different. We're not talking about a legal case, but instead an emerging legal theory. Many of you may be familiar with two legal theories that are competing and widely discussed, especially in the United States. The debate is often framed as between a theory called originalism and a theory called living tree constitutionalism. While much of the debate can center just on defining these terms, generally, originalism means that the Constitution is interpreted according to the original intent or original meaning of the drafters of the Constitution. Meanwhile, living constitutionalism is the view that the Constitution has a dynamic meaning that evolves and adapts with society, even though the text of the Constitution has not been amended. There has been a long-standing and great debate between these two approaches, but now a new theory is emerging and gaining popularity. It's called common good constitutionalism. How does it differ, and is it being applied by the courts, and where are we seeing it gain traction? Here today to discuss this are two legal experts. Xavier Foccroulle Menard is a lawyer with Norton Rose Fulbright and an expert in legal theory, and Kerry Sun is a master's student at Oxford. Now, all three of us are also associates at the UBC Centre for Constitutional Law and Legal Studies. Thanks, both of you, for joining me. Let's get to the basics. Kerry, I gave a high-level description of two other types of legal theories. How would you explain common good constitutionalism?
Thanks for having us, Christine. It's good to be here with you. So, to answer your question, the first thing I would note is that originalism and living constitutionalism are both theories of constitutional interpretation about how judges and other legal actors should interpret the Constitution. By contrast, common good constitutionalism is slightly broader than that. It's recently become prominent through the writings of Professor Adrian Vermeule at Harvard Law School. And it's a theory of constitutional law that's rooted in the classical natural law tradition of thinking. The classical natural law tradition holds, in short, that law, in its true essence, is a work of reason directed toward the common good. In a nutshell, common good constitutionalism claims that law is animated by underlying, intelligible principles of morality, that these principles contribute to and serve the common good, which is the set of conditions that enable human flourishing, and that the Constitution should be understood as a specific emanation or concretization of these general moral principles. So according to the theory, law and morality are continuous rather than entirely separate domains. And of course, the theory has a number of implications for how legal actors, such as courts or legislatures, should interpret the law, should think about justifying changes to the law, and namely that they should interpret the law in accordance with its underlying essence, the common good, where possible.
Xavier, I want to get your take on this. How would you explain the theory, and what would you add to what Kerry's laid out there?
Right. Well, so common good constitutionalism is like Kerry said, it's broader than that, but it's also a method of constitutional interpretation, and it's part of the broader classical legal tradition. So it's distinctive because it starts from a correct understanding of the nature of law, and if you understand the nature of law correctly, you're in a much better shape to be able to interpret the different statutes. And that also applies for constitutional statute, such as the Constitution Act or the Charter of Rights and Freedom. So when our elected representative pass a law or enact a law by voting on it, and then it becomes applicable, that is done for a reason, that it's done for a specific purpose. So there's an intention behind the law. And the enactment is an intentional and reasoned act done for the collective. So the goal of constitutional interpretation, according to common good constitutionalism, is to determine the intention of the legislative body, and this intention that furthers and is oriented towards the common good. So anytime our elected representative pass a law, we concretize principles of the natural law that are constitutive of the common good, and constitutional interpretations should take account of this.
So we've got to go to break in just a few seconds. There's a whole lot I want to unpack there, including these notions of morality, for example, where they come from, and what is the theory of or the approach of natural law? And another thing is, I've called this an emerging theory, but it sounds like a lot of these principles are quite old. So is it really an emerging theory? We've got to go to break now, but I'm going to talk about that when we come back.